Okay, I think we get things going. Thank you for joining us this afternoon. I think we've got a couple of interesting and thought-provoking topics to share with you today. I'm Garth O'Connor-Price. With me is my colleague Matthew Lucente from the William Buck Restructuring and Insolvency team. I will move through to a couple of little housekeeping matters. There's our general disclaimer. And I will acknowledge our country before we kick things off. So in the spirit of reconciliation, William Buck acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islanders people today. There are our mugshots, so you know who we are. Matthew will kick things off today with the first topic, which will come up on our screen now, and I'll hand over to him.
Thanks, Garth. So today I'm going to be discussing civil actions and forensic accounting, looking at the accountant's role in legal disputes and mainly how they can support clients. Feel free to ask some questions along the way. We'll also have some time at the end for any final questions. Pop those into the Q&A or the chat functions, and I'll look to get to those throughout. So here's my plan for today. My main focus is not going to be on the law itself, rather than looking at and understanding how accountants can add value to the litigation process that their clients might find themselves in, and how their actions can materially influence the outcome of disputes for their clients. So civil disputes are fundamentally different from criminal matters. In civil disputes, one party, known as the plaintiff, is seeking a remedy from another party, known as the defendant. The key point for accountants is the standard of proof. Civil claims are determined on the balance of probabilities. That is it more likely than not, in order to be able to justify the remedy that's actually being sought. Financial records are often the most important evidence in answering that question. Many disputes are determined on the quality of the records rather than actually the memories of the people that are involved in the dispute, which we'll discuss in the coming slides. The Magistrates Court generally handles the civil disputes less than $100,000, whilst the more complex disputes are generally handled by your more supreme and federal courts for claims over $100,000. So here's the life cycle of a typical civil dispute. We'll go through the key steps that the accountants become involved in, and we'll start with the pre-action steps. So this involves generally exchanging preliminary information between parties, sending letters of demand, or engaging in early discussions to really narrow the issues with accountants or lawyers. Accountants are often the first profession to identify or be informed of potential disputes relating to their client through their close understanding and relationship of the client's business. They play a critical role in supporting their clients and are often seen to be the sounding board for their clients, and often undertake some preliminary analysis for their clients as the trusted advisors that their clients would look to. They help them understand the next steps with confidence before often legal actions or next steps are sought. The accountants can help identify the recovery risks before actually commencing the actions. They can consider whether other parties have financial capacity to satisfy any judgments or settlements, which is a key action item before commencing any sort of civil action. The objective of economic damages is to make the plaintiff whole for any loss sustained as a result of the defendant's misconduct. If not settled prior, the courts determine the amount of remedy that's awarded. So I've identified on the screen some common disputes that accountants might find themselves a part of for their clients within different industries. So firstly, looking at a breach of contract or loss of profits, this results from a defendant's actions causing the plaintiff to miss out on earnings. An accountant could spot this by comparing forecasts and actual profits after a key contract was breached. We find this to be common in the construction and the manufacturing industries. It's important to consider if the client hasn't historically been making profits, there should be questions around how the dispute results in a loss of profits and what the actual profits are that the client would be losing. Next, shareholder disputes. So this involves disagreements between shareholders or partners to a transaction regarding the value of the business or the running of the business. An accountant can notice this before it formally becomes an issue. For example, if a managing shareholder, if their salary is increasing and therefore reducing the profits available for distribution to other shareholders, that's not agreed amongst the parties, that can become an issue down the track. We see this common in the family-owned businesses and professional services. Next, misappropriation of funds. This involves the intentional misuse or diversion of company funds or assets for the defendant's personal gain. This could be noticed when reconciling accounts and seeing inflated payments out of the ordinary course of business, with missing supporting documentation to justify those transactions. We find this common in the retail and non-for-profit industries. I often consider whether the three elements of the fraud triangle are present, being opportunity, pressure, and rationalization. Where all these three factors are present, the risk of fraudulent conduct is elevated. Interestingly, the courts have recognized that where a person derives a profit from their misconduct, they may be required to hand over all of the profits rather than merely compensation for the just of loss suffered. And whilst noting fraud is considered criminal, it can often be discovered accidentally rather than specifically looking for it. And finally, trademarks and patent infringements. This involves using another party's protected intellectual property without permission, resulting in economic loss or damages. An accountant may just routinely spot this by discovering a similar business name that would confuse customers, or seeing a competitor create a similar or same product as their client, which can be common in the technology and manufacturing side. So overall, the earlier you can recognize the common industry specific dispute risks, the earlier you can help your client respond. It's important to note that any expert or court would apply an appropriate discount rate to determine the present value to the damages, which is always important to make your client aware of. So how can accountants support their clients? So firstly, you look to seek an understanding of the goal outcome that the client is looking to achieve and whether their expectations are realistic. What does the client physically want to achieve in this process? Can they give you clarity around that? Or are they a bit too emotionally swept up in all of the matters? The client does have a duty to mitigate their loss, and courts often expect a party to take reasonable steps to reduce their loss. Encourage early engagement with specialists and lawyers with adequate experience in the dispute area. Our team here at William Buck act as forensic accountants and can assist with disputes and help your clients identify whether there may be actions that they become involved in. Importantly, the quality of the accounting records often determine the strength of the claim. Providing timely, accurate, and well-organized documentations to support your client's position. Your client may have the best case in the world, but without necessary documentation to support it. Proving the claim may be incredibly difficult, time-consuming, and very expensive. Accountants should also plan for discoverability that will come down the track. Assume the records may be produced and scrutinized at a later stage. It's easier to preserve these source data documents in real time whilst it is fresh rather than down the track, which may be months or years down the track. So just rounding out at the bottom of the screen, it notes accuracy is key. Without adequate supporting documentation and financial records, it is difficult for an expert to reliably quantify any loss suffered. And we'll go into the expert's accounting role in the next slide. So yeah, moving back to our litigation process, the next area accountants play a role in is during the expert evidence and lay evidence stage of litigation. So an expert is engaged to give an independent opinion on the disputed matters. Despite potentially being engaged by your client's legal team, the expert's paramount duty is to the court, not to the client who actually engages them. The expert has relevant experience and expertise to provide an opinion in an objective and unbiased manner. Expert evidence is generally provided via written reports and then oral evidence for the court if the matter proceeds. Vast majority, being well over 90% of evidence, is just provided by written reports and the matter not proceeding all the way to trial, where oral evidence would be needed to be given by the expert. In many disputes, there are more than one forensic accountant that become involved. Forensic accounting services are subject to APES 215 and are provided in different capacities. A legal team will often engage a consulting expert in the early stages of a matter. A consulting expert can assist the legal team in assessing the strengths and weaknesses of a claim, analyze financial issues, and help to assist developing case strategy. Their work is generally protected by legal professional privilege. Then, if a matter actually proceeds, an independent expert may then be engaged to provide an expert opinion for the court. Ideally, the conclusions reached by the consulting expert would broadly be consistent with the independent expert. And the restructuring and insolvency team here at William Buck have played both roles as both the consulting experts as well as the independent experts. So accountants can play a key role to ensure the experts received organized, complete, and reliable financial information. It can cause detriment to the client if the evidence relied upon by the expert turns out to be incorrect down the track. This can result in the court dismissing this evidence being brought forward and causing a negative outcome for the client. And whilst just rounding out on lay evidence, that involves evidence that comes from individuals that are involved in the event. Accountants often play a role to assist their clients present their lay evidence in the dispute. So moving into discovery, which is the main documentary evidence that emerges in a dispute from both sides. Accountants are often subpoenaed by opposing legal teams to produce specific documents relating to the dispute. Inconsistencies across documents can lead to the opposing side creating challenges to the dispute. So it's important for accountants to assume all communications or records can become discoverable. This includes emails, file notes, working papers, and other correspondence. A useful mindset for an accountant is thinking, if this file was going to be reviewed by the opposing legal team, would it reflect my professionalism and reasoning within the dispute? So overall, clear, accurate, and professional documentation protects both the client and the accountant. which I'll explore further in the next slide. The disputes, they create risk not only for clients, but also for the advisors. It's important for the accountants to understand how to protect themselves and the firm. So avoid involvement in the client fiduciary duty breaches. Ensure the accountant's actions can't be interpreted as aiding and abetting a client's improper conduct. There are specific sections in the Corps Act and case law that captures advisors' involvement in misconduct who may be held to be liable as well. Avoid acting as a shadow director and making the decisions for the client. Provide recommendations to your client rather than actually making the decisions for them. Recommend your client obtains independent legal advice whenever a matter escalates. Clients and accountants often underestimate the time consumed by litigation. Update engagement terms as dispute matter escalates. Ensure your role and scope of engagement remain appropriate. An updated engagement letter may be needed to cover the additional work and costs that you become a part of and can assist you in physically getting paid for that work that you undertake. Encourage formal shareholder agreements with your clients. A clear dispute resolution framework that are found in these agreements can allow advisors to remain objective and rely upon the agreed processes when things go pear-shaped with company shareholders. Also, if you are hit with a subpoena and not sure what to do, get some advice. Separately, we've seen accountants provide written reports as to the loss suffered for their personal clients, which is then used once litigation commences. We find these reports are heavily challenged and criticised, given it lacks independence. The best course of action that legal teams generally recommend is obtaining independent expert evidence for disputes. So before moving into questions and a quick case example, I'll look at a few observations from some real matters. So litigation costs can quickly exceed the value of the dispute. Litigation can become very expensive when there are no written agreements. There's missing source documentations. There's incomplete accounting records. The agreements are based solely on verbal arrangements or over text messages, and there is an overall lack of contemporaneous notes. A party who is successful or conducts the case unreasonably may be ordered to pay a substantial portion of the other side's legal costs, which can quickly outweigh the value of the dispute. So ensuring your clients, if they're bringing an action, has the substantial financial capacity and actually conducts the case reasonably, or else they could be hit with some adverse cost orders. On the opposite side of that, if your client is hit with a futile claim, seeking a security for cost order may be an effective strategy. It can require the other parties to provide funds up front as a security for your client's legal costs. This reduces the risk of being unable to recover those costs if the claim ultimately fails. Moving on, the best outcomes is often achieved through early resolution, not through a trial. Winning doesn't always guarantee recovery. The other party's financial capacity to satisfy a judgment is just as important as the merits of the claim. Very detailed documentation is often more reliable than recollections formed after the event by your clients as witnesses. People's memories often fade. Good governance and good documentation is the cheapest form of dispute resolution and prevention. And where there is a commingling between personal and business, it can create uncertainties when disputes do arise. Finally, most disputes are preventable with clear agreements, good communication, and proper documentation. These are all areas that accountants can make a meaningful difference in for their clients, and seeking to control the factual narrative through accurate record keeping is very vital for any disputes that come down the track. So rounding out with a hypothetical situation that an accountant might find themselves in. So I'll just read the situation here. So during a regular client catch-up, a construction client advises you that a project was terminated halfway through and believes they lost approximately $300,000 in profits that would have been earned had the project been completed. The client is frustrated by what they see as a wrongful termination and want to know whether they have grounds to commence legal action for the alleged loss of profits. So it's important before an accountant does some preliminary analysis that they actually ask a few questions to the clients to seek an understanding regarding the dispute. So in this situation, the accountant has asked whether the business had secured any replacement work after the project ended. He asked whether staff, subcontractors, and equipment were reallocated to other projects, compared forecast profits against actual profits in the financial results, considered whether any additional costs were avoided as a result of not having to complete this relevant project, and gathered some supporting documentation to determine whether claim losses could actually be substantiated. So in this situation, the client confirmed that within a short period of time, they had secured several new projects, allowing the business to keep its workforce fully utilized and continue generating revenue. The outcome, whilst the termination may have caused some loss, much of the anticipated profit was recovered through replacement work. So in this situation, it wasn't in the best interest of the client to commence a claim. So the key lesson out of this hypothetical case was a loss of profits must consider whether the client had mitigated their losses. The actual loss may be significantly less than the amount that they initially claimed. If the accountant can ask the appropriate questions, they can better understand whether the dispute is in their client's best interests. But before I hand over to Garth, I'll just put it out there to the participants if they have any questions via the Q&A chat or any experiences that they'd be happy to share. If not, Garth will commence early intervention options.
Yeah, look, while we just give a brief moment for any questions that might flow through. Look, my observation with this topic is that it is really relevant to accountants who do often hold that deep, long-term relationship with the client. Yes, they're the accountant for the business, but they often also establish a really strong relationship with the people involved and the directors and the controlling minds, and are often used as a sounding board for a variety of issues in business, including where there is potential disputes on foot. And so having a high-level understanding of the process, where it goes to, particular junctures, and the documentation required to substantiate disputes is really critical. We often find ourselves being that sounding board even within the William Buck world, where partners will brief us and have a chat about these kind of issues. Always happy for the people in our network to use us in a similar way, obligation-free, and happy to help in that regard. Of course, any questions, you can fire them through post the session to Matthew or I. We'll obviously share the slides as well, so you've got them as a reference point down the track. But I will jump into my session now, given there's no questions that have popped through. I guess the genesis of this session was really thinking about the conversations that I often have with clients and referrers and businesses, where the question is, well, what do we do and when do we do it? And so it's often framed around, well, the opportunity cost, or in this case, as I've labelled the presentation, the price of delay. And certainly there is a consequence to letting things drift, and options can narrow if appropriate action isn't taken at the earliest juncture possible. And that isn't always in that conversation, but it's about developing contingent plans. And so I thought I'd formalise those conversations and my experiences into the session today, and hopefully give you some talking points when you are also talking to your clients around what actions to take, and importantly, well, what are the consequences of not doing anything at this point in time, and then weighing up the courses of action. So there's a quick rundown of the agenda. I'm sort of splitting it into two sections. What are the opportunities lost if you don't act prior to failure? And then what are the consequences for the directors, the advisors, the controlling minds post the failure if they fail to address things in a timely manner? And then we'll finish with a couple of two real life outcomes that we've experienced. So price of delay, if you wanted to narrow it down to a nice little neat saying, it is that delay does cost value. The earlier the distress, the financial distress is identified, and a plan developed, or at least an outcome that you're seeking to achieve is crystallized and articulated and discussed, the more options remain on the table. And as that distress deepens as time elapses, those choices narrow, and the value that you could extract from the situation does erode, and that clearly plays out in our experience. And then you have the flip side of this, where the risk of personal liabilities for directors and advisors does rise sharply the longer things are let to drift. So as I said, I was using sort of a line in the sand to frame this presentation up, and that line in the sand is that point of failure. And so we'll look at what are the opportunities that are lost prior to that point in time, and then what are the consequences of letting things drift. And if you look at the opportunities pre-failure, really the constraints that shape what can be achieved are available funding, stakeholder support, and in some ways those two elements then create or equate to what time is available to the party involved to develop a plan and execute a plan, and ultimately hopefully extract them from the distress, or at least minimise the fallout from the financial distress. And then in terms of consequences of letting things drift too long in the face of all reasonable evidence, it is your things like insolvent trading and breach of duties, director penalty notices, voidable transactions, and all the kind of ASIC bans and disqualifications that could come with some really serious misconduct, and again letting things not acting when a reasonable person should have acted and done something about the situation. And we'll dive in a bit deeper on these elements as we progress through the session. So we're still in the pre-failure stage here, and so we're looking at the available funding that might be there to fund the plan, whatever shape or form that plan comes into. And a business with cash and headroom. And when I talk about headroom, it's the ability to obviously borrow under current facilities, or if there's alternative finance options out there. A company or a business with these things has options, has choices, but as those reserves run down, as lenders tighten the facility, wind back the facility, or in fact where the facility is fully drawn down, and a lender is possibly seeking to increase its security package, or indeed take enforcement action against some of the collateral under their security, those options do collapse pretty quickly. So the funding can determine whether you can trade through, or indeed actually fund an orderly wind down or restructure where you're obtaining something close to book value for the company's assets. Of course, if you're heading down the fire sale route, you're getting cents in the dollar, which is going to hurt all those involved, primarily creditors who have been funding this thing if there is a deficiency in assets to liabilities in the company. It determines whether you can access new and existing finance, or can you tap your current shareholders for support. Have you previously been to shareholders and raised capital, and have you burnt through that capital in the ensuing period, and therefore the well is dry with those parties? Can you pay for proper advice and a considered process? Yes, directors are well acquainted with running their business in times of normality, but where things do get distressed, the situation does change, and getting good advice, making sound, sensible decisions through this process is often underpinned by good advice. And so, can the company afford it? And can they run an orderly sale or recapitalisation process, as I said, rather than seeking that cents in the dollar and that low cents in the dollar type of outcome when you're going through a fire sale in a limited amount of time? Stakeholder support is essential if you're seeking to turn things around or minimise the fallout. The key stakeholders are the ones that bear the risk at this point in time. They may well participate in some upside in the future, and really it's about the company, the directors, the advisors to sell the stakeholders on what that potential upside is. How do you get to that upside, and what is the support that's required from those parties to help build that bridge through to an outcome? And the earlier they can be engaged, the more transparent you can be in where the company is at, what are the risks, and where it hopes to be. The easier it is to gain that support, the longer you leave that trust and goodwill is likely to be eroded, in some cases run out. And if you get to the very end of that spectrum, if you're looking at stakeholders that are creditors and they're seeking to enforce, whether that's through a security interest, whether that's through the stopping of supply, which could cripple the operations of the business, or whether that's through enforcing their legal rights through a statutory remand and a winding up order. That's at the extreme end, but they're the kind of things that obviously can quite quickly shorten the time available to do what is needed to be done to extract a good outcome. And so the people you need to consider as stakeholders in these kind of situations are your financiers. Will they stand still? Will they extend facilities? Will they amend facilities? Will they amend covenants? Will they overlook breaches of historical covenants? All these things need to be put on the table early. The ATO, given they do have the ability to pierce the corporate veil and make directors personally liable through DPNs, which we'll touch on earlier, you need to be engaging with them. Your compliance needs to be as good as it can be, because that also opens up different options in protection, such as safe harbour and engaging on payment arrangements. Touched on suppliers and customers. They need to have faith that A, they're going to get paid, or B, they're going to get their product or service delivered on time and to the requisite quality. So can you keep trading terms steady? Do they need something in return for them extending goodwill? Employees, I mean, the experience shows that the good employees that aren't satisfied with the direction of a company or its turnaround plans will leave as they feel, and they will have value on the market to go and obtain another job in more stable circumstances. It's quite often the lower performing employees that hang around because they realise that they maybe can't get the same kind of gig on the open market. So the key employees, the good employees, you need to make sure that they're confident enough to stay. And shareholders, obviously, when it comes to funding shortfalls and assisting with cash flow, these are the parties that, again, will benefit in a long term if things turn around. So are they willing to stay the course and again, help with the funding of the process? And so you've considered what funding is available. You considered the stakeholder support that is available or is eroding, and then you can arrive at a rough approximation of what time is available. And really, it's the resource you can't replace. And the earlier you act, the better, and that window continues to close and keep closing as that distress continues to increase. And so it matters most because you want to create that runway and create as much time as possible to plan and negotiate. It always takes much longer to bring a plan to life. It's all very well and good having it written down on a nice, neat document, but actually executing and getting the parties on board takes longer than you would think. So you need that time. The delay or the lack of time can really affect the ability to make good decisions, as you're having then to make decisions with limited information. And you can do your best, but ultimately, if you haven't got the full picture, you may not make the right decision in that point in time. And then that rushed process, it does destroy value, invites scrutiny as to the decision making. You come back to that compression of time, that time crunch. If there's a failure, there will be scrutiny around the decision making. If it hasn't been documented, discussed, articulated, the counterfactuals are considered, that there will be scrutiny that will be applied to those decisions. And then acting too late often means that those best options that were there at some point in time are off the table entirely, and you're then dealing with, well, how do we create a soft as landing as possible, which probably doesn't actually benefit in any way with the upside for the decision makers, so the directors or shareholders. At that point, really, you're probably just mitigating the downside risk, which is what we'll talk about later in the presentation. That's the things that if the decision making was incorrect, could lead to legal action, litigation, and penalties and fines and remedies in that order. So here's kind of like a visual representation of how the options narrow as the constraints tighten. And you can see sort of at the top of the slide there, you've got your workout, your turnaround, your sale and recapitalisation. These may be undertaken under a safe harbour, and if they're engaged early enough, and there's logic to the process, and the company is complying with how it needs to comply, that adds a layer of protection to the directors and the decision makers, and it's still being importantly driven by the debtor. If those elements aren't working, aren't viable, you may then move to trying to restructure through a formal process, being a voluntary administration or a small business restructure. Again, still driven by the debtor. The directors are the ones that make those appointments typically. So you're doing that with good advice and a plan before embarking on that process. In terms of debtor-driven processes, the bottom of the food chain is that voluntary liquidation. Still could be useful, is that you're controlling the process. You are making a call that the company is no longer viable, but you're calling it at a point that you have control, and you're trying to extract as much value as you can from the assets that are available, rather than letting it drift and letting them dissipate over time. And then you move into the very bottom of the food chain there, and you're looking at options that are then driven by creditors. So control is taken away from the directors at this point, and their outcomes like court liquidation. So the court winding up the company on the basis of insolvency, or a creditor with a relevant security interest, appointing a receiver or similar, to protect the collateral that underpins their security interest. So now we move to sort of the in-between area between pre and post failure, but it sort of shows what will happen if you haven't done anything and you lead into that post failure stage in what it can mean. So you start with, there are lower asset realizations, the deterioration in trading conditions, the urgency, the reduced market confidence can depress the sale outcomes. You have those higher creditor claims because often creditors have been asked to stretch their terms, or they're just not being paid within terms. Taxes are being deferred and delayed. Employees often are paid, but superannuation often is one that is missed. And any funding that has been sought to try and turn things around can increase, and therefore there are higher creditor claims in the process. And that equates to lower asset values, higher creditor claims. There is going to be a larger asset shortfall that will be available for creditors in that winding up process. And I guess a good concept to think about, well, the larger the shortfall, the greater the scrutiny exposure is going to be for those who controlled the company, what they knew at any given point in time, and when they acted, and did they act in the correct way, and should they have acted sooner or taken a different course of action in the face of the evidence and the information available to them at any given point in time. And so the formal appointment is not the risk in these situations. It's the delay before an appointment is made, which turns a solvency liquidity problem into a potential personal exposure problem, because you're coming back to that increased scrutiny of the conduct, because there is a bigger shortfall that is the creditors have borne the brunt of in the process. So we move into the post-failure element of the discussion today, and I've sort of framed it as that personal exposure for those in control of the organisation, primarily directors, and the things that they could expose themselves to if they're not taking the appropriate action in the appropriate time frame, given the circumstances. And we'll dive into each of these elements, but the common thread, as you can see on the screen, is that every one of these risks does increase and does grow the longer action is delayed by those involved in the organisation. So insolvent trading, look, many of you on the call today probably are aware that the concept of insolvent trading, but directors do have a positive duty to prevent the company incurring debts when it is insolvent, or would become insolvent by incurring those debts. And a breach of this duty can make the director personally liable to repay those debts that remain outstanding at the conclusion of the realization of the company's assets. And so what advisors should look at, should flag, should consider, is this reasonable expectation concept. So if you were to replace a director with Joe or Jane from the street, and put them in their shoes, would Joe or Jane make the same decisions, and would they have the same expectation that the company was not insolvent, or would they sit there and go, yes, it's likely insolvent, yes, it's likely there's going to be a shortfall in the company's ability to pay debts as and when they fall due, so should something have been done to mitigate those debts being incurred? So it's important to consider the compensation can equal the debts incurred whilst insolvent. So if there is some concern around the insolvency, commercially, rats and mice debts ultimately may not total to a commercial claim for insolvent trading. But if you're incurring significant debts, you're ordering materials, you're borrowing money, it can pretty clear the direct line between what the creditor has lost and it was done so at a time that the company was likely insolvent. If you're in those situations where you need to incur those debts for the sake of carrying out and executing the turnaround plan and ensuring the viability of the company, which is quite often the case. You're not incurring these debts just for the sake of it, or any kind of fraudulent or deceptive way is just needed for the business. Something like a safe harbour, or seeking the protection of safe harbour, can be an option to mitigate that risk, because you're still working towards a better outcome. So that in that point, in that context, you're entitled to incur those debts. But the safe harbour defence does depend on prompt action, and seeking the proper advice from those that understand this world and have had experience in navigating. Same. Breaches of directors' duties. I think the key message here is these duties do sharpen as the insolvency approaches, particularly weighing the interests of creditors. As we discussed previously, if there is a shortfall in assets to claims, it is ultimately the creditors who are being funding this business and bearing the risk. It's not the shareholders who have been doing so, because they're already out of the money. So that concept of the director acting in the best interest of the company actually shifts from the shareholders to the creditors as you approach or you're within that a zone or twilight of insolvency, which is a concept we like to talk about in our world when having these discussions, because it's very hard in real time to pinpoint exactly whether the company is insolvent. It often takes months of work by an expert in hindsight to determine that. So if you're looking like you're in that twilight zone, there's some uncertainty about insolvency, this is when those directors' duties do shift. And if you're the core duties under pressure are acting with care and diligence, acting in good faith and for a proper purpose. You're considering the creditor's interests. And then ultimately, if it is found that the directors have breached these duties, it can result in penalties, compensation, and disqualification from managing a corporation. We touched on it earlier. Director penalty notices are a way for the ATO to pierce that corporate veil, and probably addresses that fundamental issue with tax debt, in that it's not core to the business operations. So often, if there's a trade-off to be made, those controlling a business may choose to pay their trade suppliers and defer the tax office just to keep the lights on. Doesn't make it right, but the practical reality is this does happen. So director penalty notices are a way for the ATO to hold directors to account and make sure those kind of trade-offs don't happen too often and too regularly, and allow the ATO to get in too big of a hole to get out of. So it allows them to make the directors personally liable for unpaid PAYG, withholding, GST, and superannuation. And this is relevant to this situation because the longer things drift, if there's an absence of funding, the lodgements of ATO documentation, your BAS, your other lodgements may fall away, and that does increase the director's exposure to being pinned personally for these kind of liabilities and getting a notice. So your lodging on time does preserve the options, and your key time frame when you're dealing with this kind of notice is the 21 days, as there is a certain kind of notice being the non-lockdown notice, which does give you 21 days to make a formal appointment to avoid the personal liability component to the notice. However, if no plans have been made for a restructure or turnaround or sale or recapitalisation or whatever the plan by me, if no plans have been made prior to that notice landing, realistically, there's very little that can be done within those 21 days, and therefore the outcome of the administration, if you choose to go down that way, is obviously going to be affected by the absence of planning, and therefore you're looking at eroded value, bigger creditor claims, higher scrutiny. So I think that's sort of how you the DPNs can have a impact on your planning, and the risk of planning, and having a plan in place in the event it lands, and so you can move swiftly. Voidable transactions. So a liquidator, if appointed post that failure, they can reverse certain transactions entered into before the appointment and recover value for creditors. So the common examples are where there is an unfair preference, so a creditor receiving more than other creditors in an unfair way. Uncommercial transactions, which are deals for less than fair value. Unreasonable direct-related transactions and unfair loans and other certain related party dealings. The review period looks at the period prior to appointment, and it depends on the solvency position of the company and the parties involved in the transaction. And so the typical review period is your 6 months, where it involves unrelated parties, and on the assumption the company has been insolvent for the 6 months prior to appointment. But it can extend up to 4 years if there are related parties involved in the transactions. And you come back to, again, under pressure, decision making can be affected, and payments made under pressure can be the most vulnerable to clawing back. And if the directors themselves are involved in any of these kind of items, that they may personally find themselves needing to repay the benefits received. And then we land on finish with ASIC bans and disqualifications. So that those parties that have let things drift for far too long, ignored all reasonable evidence in front of them, which has led to creditors suffering a significant loss, may face a director ban from ASIC. And so ASIC typically may disqualify directors linked to multiple failed companies. And the courts can also impose longer disqualifications for serious breaches. Disqualification is a public event, so it's on the record. And so you come back to the record of what you've done. Was it early enough? Was it responsible? Is going to be your best protection to these kind of adverse outcomes in the failure of a company. So we'll finish off with a couple of examples. Look, the details on your screen are reasonably high level, but they do articulate two very different outcomes for the companies and the directors involved. So we have example one. Let's look at the positive side of things first. So a manufacturing business, there were some early signs of declining profitability that management had recognised. Added to that, there was an acute shock that did disrupt trading. That was around the manufacturing plant. It lost the ability to power the plant. So a voluntary administrator was appointed promptly to mitigate both the acute shock, but the gradual decline in the profitability of the business. The administrator, importantly, had access to funding to keep trading, keep the lights on, keep paying your employees. And because the distress hadn't been occurring and deepening for some time, suppliers and customers had kept faith in the process. So there was no suppliers that walked away from supplying the goods used to manufacture the products for the customers, and the customers, well, were delivered the products and orders they had on foot as at appointment, but continued to place orders to make sure that the company could be viable in the short term, whilst the options were looked at. And ultimately, this business was sold as a going concern. Again, there was a party out there that saw the goodwill of the important stakeholders was still intact. And despite it being a complex deal, they were willing to take the risk and purchased that business as a going concern. And the directors, importantly, avoided any kind of trading whilst insolvent action because they took action early and sought the protection of an administration rather than letting things drift. And so you can pair that with an example of a business that acted far too late, this being a travel wholesale business. The performance of the business, and more importantly, probably the funding options declined for months without decisive action. It was a business based in Australia, but part of a global group, being a seasonal type business. Funds were moved around to address that seasonality, but enough controls weren't put on that process to make sure there was adequate funding in the Australian business, which hampered its operations. There was a key client that terminated their distribution agreement with the business, which meant they couldn't sell a tour, which was almost their key flagship product that they were selling. At the time of appointment, there was insufficient funding to trade at full capacity. Most of the staff were stood down very shortly after appointment, and certainly not the capacity to honour the travel packages that had been purchased well in advance of the appointment. Therefore, these people were out of pocket and also couldn't go on their tours, and therefore any kind of goodwill, any brand goodwill in the market was instantly destroyed. And as I said there, it's tarnished. And there was limited time for interested parties to complete their due diligence and understand the business and understand whether it would be worth actually injecting that capital to make good on these customers, and therefore that the business was shut down. And then ultimately the director was forced to settle an insolvent trading claim for his failure to act in a prompt due time. So I'll finish off with a couple of key takeaways. The key messages running through the presentation today is act early. Your options of value, goodwill erode with that delay. So the earlier you engage, the more you can save. If you're in the advisor's shoes, protecting the client is encouraging them to get early advice, which in turn will keep the funding, keep the stakeholder advice, and buy time potentially for a plan to be executed and have options on the table when needed. And whatever you're doing, do view the process, the decision making, the actions through the lens of is there an increase through this action to personal risk? And you come back to prompt action is the best defense. Often you're entitled to let things play out, but you need to have a rationale and a sound basis for doing so. Otherwise, you are exposing yourself to things like insolvent trading, penalty notices, and clawbacks and bans. So that's us hitting bang on 1 o'clock. Happy to take any questions through the live chat or raising your hand. If not, as I said at the midpoint of the session today, happy for anyone to reach out to Matthew or I and bounce off any queries you might have. We will share the slides and the recording if you feel the need to listen to us twice. You'll have access to that on demand and as needed. But appreciate you jumping on today. Hopefully you found it thought-provoking, and the next time one of these situations arises with your clients, you're more equipped or better equipped to assist them through the process. And at that point, I think we will conclude. So thank you very much.
Thanks all.